The United States Supreme Court agreed this week to hear 3 cases that could help expand or further degrade federal protections for queer and trans people in the workplace. At issue in these cases is the question of whether or not Title VII of the 1964 Civil Rights Act expressly prohibits employment discrimination against queer and trans people. Before we continue, here's a reminder to hit that subscribe button and turn on notifications so you'll always be the first to know about great queer space content like this. The 3 cases that will be heard are Altitude Express versus Zarda and Bostock versus Clayton County, Georgia, both of which involve men who were fired from their jobs for being gay, and RG and G.R. Harris Funeral Homes versus the Equal Opportunity Employment Commission, filed by a trans woman who was fired after telling her boss that she would be transitioning. They will be heard by the Supreme Court this coming fall, which would likely mean their decision could drop during the thick of the 2020 presidential campaign. There is currently no federal law that expressly forbids employment discrimination of queer and trans people. As a result, there are still 26 U.S. states where people can legally be fired because of being queer and/or transgender. Title VII of the 1964 Civil Rights Act prohibits employment discrimination because of sex, though, and multiple federal courts have ruled that discriminating against queer and trans people falls under that classification. At issue, then, is whether or not the definition of sex in Title VII includes sexual orientation and gender identity. The announcement from the Supreme Court comes on the heels of the reintroduction of the Equality Act in Congress. The purpose of the Equality Act is stated as prohibiting discrimination on the basis of sex, gender identity, and sexual orientation. It goes well beyond employment discrimination, adding those categories as federally protected classes when it comes to housing, services, and public accommodation. The Equality Act was reintroduced with broad support from both sides of the aisle in Congress, with both Democrat and Republican sponsors, and 287 co-sponsors in total, the most initial support in Congress that any piece of pro-queer and trans legislation has ever received. Should the Supreme Court decide on a narrow definition of sex in Title VII, it could spell disaster for both queer and trans people, who would suddenly find themselves facing a mishmash of potentially discriminatory local and state regulations to contend with. Even if the conservative-leaning court decides in favor of including protections for queer and trans people under Title VII of the 1964 Civil Rights Act, queer and trans people would still be left without federal protections when it comes to things such as housing and public accommodation. Thanks for watching this Queer Space video. Don't forget to like, share, and subscribe. We'll see you next time.